Kirti, can you hear me?
Yes, sir.
Please start.
Sure, sir. Am I audible?
Yeah, please go ahead.
Good evening, everyone. I hope you all are doing well in these unprecedented times. I welcome you all to today's webinar on understanding the Madrid system for international registration of marks. I am Kirti Talreja, currently working as a research intern with FICCI IPR division under the guidance of Mr. Devesh Srivastav. FICCI IPR division has been regularly organizing webinars for the benefit of the stakeholders. FICCI is the voice of India's business industry, and through its IPR division, it has been constantly endeavoring to raise awareness about intellectual property in India. Taking this very objective forward, the Cell for Promotion and Management, Department of Promotion and Industry and Internal Trade, along with FICCI, launched the 100 webinar series in March 2020. Since its launch, the webinar series had attained great success, for which we are extremely thankful to our participants and the speakers for sharing their knowledge. On behalf of FICCI, I take this opportunity to welcome you all to this webinar on understanding the Madrid system for international registration of marks. With this, I would now like to introduce you all to our eminent speaker for today's session, Mr. Matthews Verghese. Mr. Matthews is a managing associate with Intel Advocare and is an esteemed member of the FICCI IP Forum. He has also extensive work experience of around 12 years in trademark, copyright, and design prosecution and handles both Indian and international clients. His practice focuses on advising on all aspects of trademarks, copyright, and design prosecution, including clearance searches, application, strategic development, and management of worldwide trademark, copyright, and design portfolios. With prior experience in handling matters in contentious and non-contentious field, his experience and focus is to assist clients with commercial and holistic solutions to the numerous intellectual property problems. His experience has also led him to handle clients across various industries such as apparel, luxury, pharmaceuticals, FMCG, technology, and retail. Mr. Matthews regularly appears before the 5 trademarks registries in India and has in-depth knowledge as to its working. Pursuant to completing his law, Mr. Matthews also went on to complete his master's in intellectual property laws from Queen Mary University of London. Mr. Matthews is also an adjunct professor for intellectual property laws at his alma mater for the last 5 years. His teaching activity adds yet another dimension to his personality and keeps him abreast with the latest happenings in the field of intellectual property law. It is indeed an honor to have you with us today, sir. We welcome you.
Thank you. Thank you, Kriti. At the outset, let me thank FICCI and for hosting this webinar series. Devesh, thank you so much for having me over for the same. And shall we get started?
Just a second, sir, before you begin the webinar. Before proceeding, I would like all the participants to adhere to some basic rules during the session. First, during the webinar, all the participants are requested to turn off their audio and video for an uninterrupted session. And second, all the participants are hereby requested to hold their queries, if any, for the same shall be addressed at the end in the question and answer round. I would now hand over the session to Mr. Matthews Verghese for his presentation. Over to you, sir.
Thank you, Kriti. So I'm just going to share my screen. There we go. OK, so we are here today as part of FICCI's 100 webinar series on IP. And the topic that we are going to take up is understanding the Madrid system for international registration of trademarks. I often come across clients who ask me 2 things. 1, we would like to file all over the world. And 2, we would like to do it without incurring too much costs. So when I say yes, it is possible to file and I give them the costs, 2 things happen. Either the client says yes, or the client runs away and does not come back ever again. So this was a problem that we had prior to 2013 for numerous clients, only because the costs were very high. It wasn't just the cost, it was also the fact that one had to go to numerous countries, numerous associates in all of these countries to kind of get your application registered. So it was a very, very tedious process, especially for large MNCs who had global interests. And to our help came the Madrid system. Now, the Madrid system is a very convenient and cost-effective solution for registering and managing trademarks worldwide. Just like I just stated earlier, through one application, one is now able to get their trademarks registered in numerous countries across the world. So we have the Madrid system, which consists of 1, the Guide to International Registration of Trademarks, 2, the common regulations, 3, the Madrid Agreement, and we have the Madrid Protocol. Now, in the next couple of slides, we'll go over what these are before then going on to understanding what the concept is in India. So the Madrid Agreement basically came about in 1891. It was enacted to bring a single inexpensive process of registration of trademarks globally. That's the cost aspect that I spoke about even earlier. It eliminated the need for filing separate applications in different countries. Convenience, one of the most important things for any client. But due to certain defects, most countries did not accede to the agreement, thus defeating the purpose for which it was set up. Then came about the Madrid Protocol. It was enacted to remedy the defects of the Madrid Agreement. It was more flexible and accommodating than the agreement. And we now, till date, have a total of 106 countries which are parties to the protocol. Imagine today, I can, through one single application, go to 106 different countries, whereas previously I had to approach 106 different associates, get 106 different cost codes, give 106 of these to the client who then had to get it approved, subsequent which they would give me instructions to which I would give my associate instructions. Such a lengthy process just eliminated in the click of a button or by the signing of the Madrid Protocol. Regulations are equivalent to the rules that we have in respect of trademarks in India. So let's say you have the Trademarks Act and you have the Trademark Rules 2017. So the regulations and the protocol are nothing but, or they're known as common regulations, are nothing but the rules as to how the protocol functions. And last, we have the Guide to the International Registration of Trademarks. This is what it is. It's a guide, nothing more, nothing less. It acts as a Bible to maybe explaining to officials, member states, unions, stakeholders, basically the essential provisions of the agreement, protocol, and the regulations. Now, the differences between the Madrid Protocol and agreement are quite vast. I've broken them down into 2 categories on your screen, as you can see. It is a common misunderstanding when we speak that we say we are part of the Madrid Agreement rather than the Madrid Protocol. Please note that India is a part of the Madrid Protocol, not a Madrid Agreement. Okay, and so are a host of other different countries. So the right use of the terminology is as important as understanding what these terminologies mean. So the differences between both are very simple. Under the agreement, an application could only be filed on the basis of a basic registration, while in respect of the protocol, you could file it on the basis of a pending application or a basic registration. So earlier, you could only file through the Madrid Agreement if your mark in your home country was registered. You could not file it till it became registered. You cannot file it at the pending stage, whereas the protocol allows you to file it even if your mark is pending. The Trademark Office, as far as the agreement is concerned, has to inform WIPO of any objections within 12 months. In respect to the protocol, the countries which signed were given 2 options, either do it within 12 months or within a time period of 18 months. So within a time period of 18 months, the entire process needs to be completed. In respect of the agreement, the term of registration was 20 years, whereas the term of registration in respect to the protocol is 10 years. Now, this is a vast difference because numerous countries or most countries of the world follow a time period of registration of 10 years as far as trademark law is concerned. In respect of the language, Madrid Agreement allowed only an application to be filed in French, whereas the Madrid Protocol increased this by giving us options such as Spanish and English as well. the Madrid Agreement do not allow for transformation into a national application if the basic registration ceased to exist, whereas that option was there on the table as far as the protocol was concerned. What is transformation is something that I will deal with slightly later in my presentation. So the procedure, now an international application filed under the Madrid process is 3 stages. Okay, so the first stage is basically the Office of Origin. Second is at the WIPO, or the International Bureau at the World Intellectual Property Organization. And the third is at the designated country. We will deal with each of these 3 things in a little bit more detail coming forward. Stage 1. So we file a basic application. And that basic application originates from what is known as the Office of Origin. It then goes to the International Bureau at the World Intellectual Property Organization, which then examines the mark formally and then publishes the mark in the international registration in the Gazette and then issues a certificate of registration. It then notifies the designated countries that they have received such an application, so that the designated countries can then go on to examine the application within the purview of their local law. So let me just change this out and explain this as far as India is concerned. So let's say we are all, let's say I'm an Indian company. I file an application with the Indian Trademarks Registry. That's my basic mark from which I derive my basis. On the basis of my basic application filed in India, I say that I would like to designate it to X, Y, and Z countries. And I file through the Indian Trademark Registry a form which is then forwarded to the International Bureau located in World Intellectual Property Organization. They formally examine the trademark and issue a certificate of registration if everything is in order, and then continue to forward my application to the designated countries of X, Y, and Z, who then proceed to examine it under their local laws. So this is practically how it works if I was to file it from an Indian perspective. Let's look at what Office of Origin means. Now, Office of Origin is nothing but the office from which the basic application originates. So if I was an Indian citizen, if I use my prior example and I file through the Indian Trademarks Registry, my Office of Origin is the Indian Trademarks Registry. So just as I explained slightly earlier, I file a basic application and I then proceed to file my Madrid application on the basis of my basic application through the Madrid system using the online forms, which is then forwarded to WIPO subsequent to verification by the Indian Trademarks Registry. Now, what does the Indian Trademarks Registry verify? They verify that my Madrid application is exact to my basic application. There are no differences. All the particulars are in order. They basically are a mirror image of my basic application, and whether I filed my power of attorney, so on and so forth. And on the basis of this, they will then proceed to send it to International Bureau at WIPO. Right. So this is what happens at WIPO. As far as the World Intellectual Property Organization is concerned, now that's the organization, and International Bureau is the equivalent of the Trademark Registry of India. OK, so the International Bureau examines the application for formalities only. They don't go into any substantive law. They just check whether everything is in order. And once they feel everything is in order, they publish it and register it in the International Gazette. Let's say something is not in order. Let's say the applicant has not paid his fee, or there's a discrepancy in the name or the address. Then they issue an irregularity notice. Now, once the irregularity notice is issued, you are to take action within 3 months on receipt of the irregularity notice. Now, how is the irregularity notice served to you? It's served through 2 means. One, it's emailed directly to you. And the second, it's sent to your Office of Origin, or it will be sent to the Indian Trademarks Registry in my case, and the Indian Trademarks Registry will then inform me saying that there has been an irregularity notice which has been issued. Kindly attend to the same. So if there's no irregularity notices, it proceeds to publication and registration. If there's an irregularity notice, I have to contend with it. I have to file a response to it, subsequent to which it is examined again. And if everything is in order, it is then proceeded to publication in the WIPO Gazette. and subsequently registered, and a certificate of registration is issued. Now, the common misunderstanding is that I receive the certificate of registration, my mark is registered. No, it is not so. It is just you could say a stamping that the WIPO finds it in order, because it has to now be passed by the local laws, or has to be scrutinized or examined by the local laws of all the designated countries that one has opted for at the time of filing. By designated countries, I mean the countries of interest to me as a client. So yeah, so this is the office of the designated country. So WIPO finds it in order, they issue it, they send my certificate of registration, and they subsequently send my application to be examined in, let's say, UK and USA. Okay, so the trademark registries of UK and USA will then examine it as per their law. They will see whether the basic tenets of their law has been followed. Is it in line with it? And if not, they will issue a provisional refusal. Another common mistake that I always find is that when a client sees the word provisional refusal, they believe that the mark has been refused. That is not so. The term provisional refusal is used by the International Bureau to refer to the examination reports issued by various countries. So it's equivalent to what we call as the first examination report under Indian trademark law. Now, once the provisional refusal is received, of course, a response has to be filed. And the response has to be filed within a time limit as specified under local law. How this works is basically, once the provisional refusal is, let's say, issued by the United Kingdom, if I am an Indian applicant, I have to now, it's served on me, I have to now take it to an attorney or a law firm based in the United Kingdom to be able to respond to it. And vice versa. We will deal with both situations slightly earlier in the Indian context. And subsequent to filing a response to the provisional refusal, if the local law determines that a hearing is to be held, a hearing is held. If there is no hearing held, there is no hearing held. And if they are satisfied with the response which is filed, the mark is then published and a statement of grant of protection is issued by the designated country. It is only when the statement of grant of protection, which is another terminology which is equivalent to what we know as a certificate of registration, is issued, can one say my mark is registered in the United Kingdom as per the international registration, or registered in the United States as per my international registration, and not before that. Now, let's understand some concepts which I may have touched upon while I've been doing this presentation. So I've talked about subsequent designations, and I've talked about something called as transformation as well. So subsequent designations is something very interesting because it allows one, let's say today, my company policy is that I have a market in the United Kingdom and USA, so I want to designate there and I designated there. 2 years down the line, I have a requirement. I want to now go into Chile, Spain, and another country. So do I have to file a new application? That would be the easiest way through. But law does allow, the Madrid system does allow for something known as subsequent designations, which can be filed to basically extend your international registration to the new countries of Chile and Spain and so on and so forth, on the basis of your initial registration or application that you already have. And the designation shall be effective from the date on which it is recorded in the international register. Okay. The next terminology is transformation. I had touched upon this in my earlier slides. Now, transformation basically is a slightly easier concept to understand. It's basically what the word says. I transform my international registration to a domestic application or a registration. Now, I do this if my basic mark is threatened or cancelled. So an international registration is always dependent on the basic application or basic registration from your home country. If that basic application ceases to exist, if that basic application or registration is cancelled or attacked by someone else and subsequently cancelled, then the designations are also affected. This is why it is not prudent for one to, file Madrid applications for all your trademarks, you have to pick and choose what is important. You have to pick and choose what can be done and what cannot be done. Because if you have a mark which is low on distinctive value, has got it's generic in nature, you may not want to file a Madrid application, because what happens is that that kind of mark would face problems in the future. And if such problems are faced, you would have the risk of having it cancelled or abandoned, subsequent to which your designations or your international application will also stand affected. Thus, the advantage of costs which you saved initially would come back on the table, and you would still incur a huge cost by doing transforming in various countries. And in those jurisdictions which do not allow transformation, then you would have to file a fresh application through the earlier methodology which was there, which was basically approaching an associate in another country and taking it forward through the process which is laid down. Transformation must be done within a 3-month time period of the basic marks cancellation, and must cover all goods and services as like the basic registration itself. So there is no concept of adding on to the specification at a later date. Now, advantages. There's always a lot of advantages of the Madrid system, but one must pick and choose what one files through the Madrid application rather than file everything. The most important advantage is, of course, convenience. A single application which can be filed to almost 106 plus countries. That's convenient. Cost effectiveness. You don't have to pay professional fee for every associate that you had to earn. The earlier system had to approach basically. So let's say I as a company wanted to file in 50 different jurisdictions. In the earlier times, I had to approach 50 different associates or law firms and incur professional fee of those 50 plus my attorney/agent in India. So by filing this one application, I am making, or rather I'm doing away with the professional fee for all of those 50 associates. Just imagine the amount of money that I would save. And I'm talking about USD or euros currently here. I'm not even talking about Indian rupees. Okay. You also have a bundle of registrations in various countries, which basically means that you have a much more easier way of compiling all your data and keeping it all together. You have one expiry date, one renewal date, thus making your life much easier as an in-house counsel. You don't have to keep track of 50 plus applications and 50 plus dates with 50 plus renewal deadlines which are coming up in the future. Also, a foreign attorney or an agent only need be appointed in cases where a provisional refusal is issued by the trademark registry of the designated country. In an instance where no provisional refusal is issued or brought out, a foreign attorney need not be appointed. Thus, again, cost saving. Now let's look at it from an Indian perspective. Now we are sitting in India, so let's understand it from an Indian perspective. Now when we look at it from an Indian perspective, there is two things that we need to look at, or rather I've divided it into two halves. One is what we refer to as an Indian application originating from India, shortly known as IAOI, or secondly, we refer to it as International Registration Designating India, or an IRDI. So basically the first one, IAOI, is one application which originates from India outward, and IRDIs are basically applications where the applicant has designated India as one of the countries of interest. Under Indian trademark law,
Obviously, can't hear you.
Kriti, am I back up?
Yes, sir. Now we can hear you. Now you're audible.
Kriti?
Yes, sir.
Yes, sir. Okay, sorry. I think I got disconnected. Hold
Yes.
on. Right. So we were, apologies all. I think we went off slightly. All right. Okay, I'll just come back to the slide at which we were dealing with this one. So as far as India is concerned, the sections and the law, basically the law was changed to incorporate the applications which were filed through the Madrid system. So if you look at the Act, Section 36A and 236G deal with the international applications under the Madrid Protocol, whereas the Trademark Rules 2017, which replaced the earlier rules of 1958, has Rules 62 to 74, which deal with international applications. Now, what they basically lay out is one, the responsibility of the trademark registry as an office of origin, as well as the office of designated contracting party, the manner of examination, the invalidation of protection, and effect of cancellation of international registration, which can occur. So that's what these sections and rules basically deal with. And section 36E is quite interesting because it says that sections 9 to 21 and then 63 to 74 shall apply in respect of an international application as if such application was one made under section 18. So that is another interesting section which basically talks about how examination, opposition, etc. need to be filed and taken forward. So let's look at the responsibilities of the Indian Trademark Registry as an office of origin. So as an office of origin, its first responsibility is verification of the application which is filed by each of us. So once I have my basic application, I file my international application and that is verified by the Indian Trademarks Registry. The fee for this is of course 5,000 rupees, which is the handling fee. And if there is a deficiency, they issue a deficiency letter, which I'm supposed to respond and remedy within 1 month. And if not, they certify it and then they send it to Madrid. And practically the time period which we have always found is they send it usually on a Monday to the World Intellectual Property Organization. They also receive any irregularity letters which is issued by the WIPO and they transmit it to us, which needs to be rectified within a time period of 3 months. Now, these irregularities could be anything ranging from the address not being correct to the applicant's name being different to fee not being paid or the correct amount of fee not be paid. So these are examples of irregularities which are issued in the past. And the last is the communication as far as the cessation of a basic application is concerned. So like I stated earlier, if something happens to the basic application, if it's cancelled, if it's opposed, subsequent to which the mark is abandoned, this is then communicated to the WIPO, who then communicates it to the designated countries, thus expunging all the records in respect of that international registration. Now, when we look at it from an IRDI perspective, the Indian Trademark Registry, if they receive an application which has been filed, let's say through the UK IPO, their first job is to examine it under the provisions of law. As far as examination is concerned, they will examine it under section 9 and 11, just like they would to any basic normal domestic application. The only difference being that the objections, if any, have to be notified to WIPO as early as possible because the entire process has to be completed within 18 months. subsequent to an examination being done and a provisional refusal being raised, a response is submitted. There could be a hearing, there could not be a hearing. It is up to the Trademarks Registry and it's their discretionary power to do so. And they will then publish it in the Trademarks Journal, just like a domestic application. And the notice of opposition, or the time period for the notice of opposition, shall also kick in. If the mark is opposed, it will follow all basic tenets of opposition procedure, which is laid down as per law in the Indian Trademarks Registry. Also, any renewals, amendments, etc., which are filed at the World Intellectual Property Organization or the International Bureau of the WIPO is then notified to the Trademarks Registry so that their records can also be accordingly updated. This is basically what the Indian Trademark Registry does in case they receive an international application from outside India. Now, provisional refusals. Now, this is what a lot of agents do a lot of work on. One thing that happened with the ascension to the Madrid Protocol was that we as attorneys started receiving lesser number of applications from international clients. They started filing it through the Madrid through using the Madrid Protocol, and then but our number of provisional refusals started increasing as well. So, like I stated earlier, provisional refusal is issued within a time period of 18 months. It is based on section 9, 11 and 13. Those are the basic sections, basically on absolute grounds, on relative grounds, and in respect of whether it's part of the it's basically names which are not allowed to be registered. Basically, they look at it and examine it and issue a provisional refusal if required. If a provisional refusal is issued, the response has to be filed through an agent whose address is in India. So this is where clients approach us now and request that we file a response to the provisional refusal, which is equivalent to the examination report that is issued for domestic applications. When we file the response, earlier when the system started, it was not required for a request in form TMM to be filed to bring ourselves as the agent on record. But subsequently, the Indian Trademarks Registry has laid down in their practice that a request needs to be filed to bring ourselves as the agent on record along with the power of attorney, and then subsequently file the response to the provisional refusal. It has to be filed within 1 month of notification to the applicant by the World Intellectual Property Organization. So if you get a provisional refusal, there is a first page which basically says date on which the applicant was notified or notified to the holder. That is the date from which we need to calculate the 1 month time period. Extensions can be sought just like a domestic application for filing a response for a period of 1 month. Hearings. Yes, hearings are held for IRDI matters at the discretion of the registrar if they so wish to hold it. If they do not wish to hold it and they're satisfied with the response, they go ahead to publish it in the Trademarks Journal. A funny part about hearings is that the Madrid section of the Trademarks Registry sits out of Mumbai. We have made numerous representations, or rather stakeholders have made numerous representations to have it opened up to registries all across India. India, unlike many jurisdictions in the world, has 5 different registries, as you're all aware of. So we have requested that it be opened up in Delhi, it be opened up in various other places. Till date, there has been no progress on that front. With the advent of virtual hearings, we hope that this will now also gather steam, and we are maybe looking at a future where IRDI matters can be held virtually and I can attend them sitting out of Delhi, NCR, or wherever I'm sitting out of. And in a hearing, a registrar may decide to either accept the mark or he may refuse it, just like he would in a domestic application. And if refused, what is known as a confirmation of total provisional refusal is then issued, which is then subsequently conveyed to the International Bureau at WIPO. Now, this system is not without its problems. Every system has problems, and the Madrid system is not far behind as well. The first problem that we as Indians face, or Indian attorneys face practically, is that there is no request for division of an application. I had earlier stated that the domestic law is applicable to international registrations as well. Domestic law allows us, as per under the Trademarks Act and the trademark rules, to file a division application. This basically means that if I file a multi-class application in class 10 and 25, I could divide it into 2 single class applications. However, in respect of a Madrid application, this does not seem to be the case. The TMR has issued a notification which says that division request will not be accepted, which is against the law which is currently there. Again, stakeholders are making representations to kind of rectify the situation as far as divisions are concerned. Amendment requests. Let's say I want to delete some specification of goods or services from my specification of goods which I submitted as part of my basic application or my international registration. Again, this cannot be done through the Indian TMR. One needs to approach the WIPO and file a form known as MM6, which has to then be given to the agent, who can then submit it at the TMR along with the response to the provisional refusal to show that certain goods and services have been deleted, which will then be subsequently recorded by the Indian TMR. Again, a slight problem because in domestic applications, I could file an amendment at any stage if required to do so. So again, a gray area which needs to be rectified. Hearings, like I stated slightly earlier, currently only applicable in Mumbai and not any other trademark registry which are there across India. Transformation, again, not allowed in India. There is no procedure or a form for the transformation of an international application or domestic application in India. So if today an IRDI is cancelled, the applicant or the client has no other recourse but to file a fresh application through domestically if required to take its rights forward in India. Further, in respect of priority, there is a little bit of a hindrance here because only a single priority can be claimed in respect of all goods and services in a Madrid application. A multiple priority cannot be claimed in India. Now, this is where I kind of end my presentation. The system that we have with us is very, very useful. Does it have its problems? Yes, it does. Has it improved from what it was when it initially started in 2013, 2014? It has drastically improved. There are loads of improvements still in the works. Stakeholders are putting up representations on a daily basis to improve the system. And as practitioners, we look forward to such improvements because it greatly aids us in the practice of law. India is, I would say, still at a nascent stage as far as Madrid applications are concerned. Therefore, the scope and the growth of it is very, very, very large. There is still a lot of knowledge which needs to be shared, a lot of understanding which is required both from client's perspective as well as from the trademark registry's perspective. And they seem to be doing it now on a case-to-case basis as and when they face problems. That is what practically we have seen and encountered. Kriti, over to you.
Am I audible, sir?
Yes, Kriti.
Thank you so much, sir, for such an illustrious knowledge of yours. Now I hand over the session to Shreya for the question and answer round.
Right.
Thank you so much, Kriti, and good afternoon, everybody. I'm Shreya Kumaria, and I'm currently interning at our FICCI IPR division. Today, I'll be handling the question answer session for this webinar. First of all, sir, I would like to thank you for your insightful words and taking out your valuable time for us today. In the meantime, we had received a few questions and I'll be addressing them towards you. In case any participant wishes to ask a question, they may raise their hand, and if the time permits us to do so, we shall take up the question. So with this, I'll forward the first question to you, sir. So how has Brexit affected the Madrid filing system? Do we have to designate EU IPO still to file an application in Great Britain?
So Brexit rules are still coming, or there is still clarity being sought on the Brexit rules. Currently, if you already have a registration, the UK IPO is allowing you to keep it. though they will issue new application numbers, or they will basically issue an alphabet in front of the application number which is already there, so that the stakeholders can understand that it was a Brexit application initially. There is still a lot more clarity which is required from the UK IPO as to how they're going to finally, secede from the UK or the European Union as far as trademark law is concerned. So that's still a burning issue which is getting rectified on a daily basis. COVID kind of put a spanner in the works. So now they are strict pressed for time. But they have assured that no stakeholders' rights will be affected adversely in this kind of a scenario. So that is something that we are hopeful of. So we haven't encountered any problems till date in respect of our clients. So we hope that it all works out for everyone else as well.
Thank you, sir. I'll move forward to the next question.
Yep.
How effective is the Madrid system in your opinion as a part of the business, and should it be incorporated in the overall IP strategy of a big business?
Yes, so it is very, very effective for a business to have Madrid applications. I'm talking about a business which, we are all looking out towards now. India is no longer a closed economy. Every business is trying to look outward to countries across the world to move forward. And it's become a global economy, if you may call it. So therefore, if I as a business was to encounter, and costs are always of optimum, so costs always are a concern. Today, I as a business holder would like to get my rights protected in as many countries of interest where I would like to do my business, but at a very cost-effective manner and means. The Madrid system allows me to do that. And it also gives me the convenience as far as record keeping is concerned, because having to keep 100 applications, 100 different dates, hiring a person to monitor all that, and maybe even a software to incorporate the details becomes a very, very tedious and tedious process with a lot of cost implications. So convenience and costs, these are two things which and the Madrid system gives the business owner that both convenience and a cost-effective manner to protect their rights across the world.
All right, sir. Next question is, can I directly file an application through Madrid without filing an application if I don't have any intention to use the trademark in India? I'm an Indian citizen, and what would you recommend in this situation?
Okay, so you may not have an intention. So you may not intend to use your trademark in India. That's fine. But if you wanted to file a Madrid application, you would have to initially file one application in India, subsequent to which you can then designate it to other countries across the world. Different because you may not be using it currently, but we may look to use it in the future. So that is dependent on the business interest, and that would change from business owner to business owner, client to client.
All right, sir. So next question is, what is the difference between filing an application in black and white combination and in color combination? Hello, sir. Can you hear me?
Sorry, Shreya, I didn't get you.
Sorry, yes. So
Yeah,
I'll repeat. What is the difference between filing an application in black and white combination and in color combination? Hello?
Hello. Yeah, Shreya, I can hear you. Could you just repeat that again, Shreya, please?
Yes, sir. What is the difference between filing an application in black and white combination and in color combination?
Right. So if you file it in color, you are restricted to the color. If you file it in black and white, you have a broader scope of protection. As a business holder or a stakeholder or a client, always look to have the largest or the broadest scope of protection so that you can enforce it against others. That's the best legal strategy to adopt in that kind of a scenario.
All right, sir. What should an MSME go for in case the trademark is a logo mark?
As far as color is concerned, or is it
Yes,
just
sir. Yes.
Black and white, definitely, unless you are very well set on your color. See, what happens is that, let's say you file it in color, you're restricted to the colors because you have to specify your colors. If you have it in color and you file a Madrid application, you have to specify the color: black, green, blue, red, whatever it is. You may change that color in the future, which would then mean that you need to file another application as a whole. So if you're not sure, and an MSME may not be sure about their colors because they may look to see what works and what doesn't work. And if you're an MSME or a startup, go for it in black and white, get your broader scope of protection. Don't restrict yourself, don't limit yourself, keep it open, because that would help you in the future as well.
Okay, sir. If any religious symbol is used in a trademark, does it make it legal or not?
No, use of a religious symbol is prohibited under Indian law. So to take an example, if you have the Om symbol, you can't file a application for it because that is prohibited under law. Hence, you would not get a registration for it, which ultimately defeats your purpose of getting it registered in another country. So your basic application, which you file in India, that has to confer with the law, that has to be registrable, because if it is not, you tend to lose your international application as well, because the the international application kind of draws its energy and force from the basic application. So it's just an extension of it. So if your basic application is affected, the entire thing is affected. You could consider the basic application like a base to your building. So if the pillars break, then the entire thing comes crumbling down.
Okay, sir. So next question is, if an examination report declining the registration of my mark in the US, do I have to appoint a US attorney to handle my case, or an Indian attorney could do so?
No, if you're designated to the United States and a provisional refusal is raised under US law, you have to appoint, or you have to get a US attorney to respond to the provisional refusal. And that's how it works as far as the Madrid system is concerned.
All right, sir. How has the current COVID-19 crisis affected the timelines for international registration, where provisional refusals have been issued and the time limit expires during the lockdown in the designated country?
So if the time period, so firstly, as far as COVID is concerned, yes, there was a slight lag in the number of provisional refusals which were issued. As far as the timeline is concerned, it would be dependent on country to country what the law states. In India, the Supreme Court judgment that we have as far as statutory deadlines is still applicable. So there is no statutory deadline which can be adhered to currently as per that particular judgment. However, in other countries, there have been extensions which have been given. There are time periods specified in which certain things need to be done. So it is dependent on the local law as far as COVID is concerned.
Okay, sir. So the last question, what is the WIPO Madrid Monitor and Global Brand Database? Is it mandatory to conduct a trademark search internationally before filing a Madrid application?
So the WIPO, or the Madrid Monitor, the WIPO Global Database is nothing but accumulation or a collection of all marks or registries. A couple of registries have agreed to open up their data to the International Bureau. So one can check up on provisional refusals which are issued. One can check up on various things as far as international registrations are concerned, because these countries have agreed to open it up for them and allow WIPO to have access to their databases. What was the second part of the question? Was what was Shreya?
Sir, is it mandatory to conduct a trademark search internationally before filing a Madrid application?
Yes. As a lawyer, I would always advise my client to conduct a trademark search. Yes, we are looking at cost-effective means of getting your trademark applied for and registered, and that's the basic reason for going through a Madrid application on the Madrid protocol. But searching or doing a trademark search is very, very important, because the X amount of money that one spends in a search is money well spent. It's like an investment. So if I am not able to get registration in a certain country, I should definitely not go for it. I should definitely not designate it, because my chances of success are very low. And I can relate to this because I actually convinced a client recently, just before lockdown, to do it. He was very, very hesitant. It took over 2 hours of convincing him to go for a trademark search in the United Kingdom, which he had major interests in. And surprises, when we did a trademark search in the UK using a UK-based attorney, the results showed that that particular trademark could not be filed in the United Kingdom because there was already an identical mark there. This changed the entire strategy for the client, who then decided not to file it in the United Kingdom because he understood that the chances of success were close to 0. If without having done that trademark search, he had filed his international application, he may have had to spend more money removing that particular designation from the international application than he had spent for doing the trademark search. So doing a trademark search is a prudent step, or rather always the first step that one should adopt to get or rather to assess whether one can file in a particular country. It's akin to all of us doing research before purchasing a phone. We all check on YouTube, we all look at the reviews, we all read it before purchasing any phone. It's very akin to that. So that is how one can, relate it. I would not purchase a phone today without, reading some reviews about it. Neither would any of us here on this webinar today. So just consider it like that. You're doing your research before you put in your money and invest and get something done in a particular country.
All right, sir. So with this, we have exhausted the questions that were put up by the participants.
Sure.
On this note, I would like to conclude the question answer session. It was indeed a very informative and enlightening session. I sincerely hope that all the participants have benefited with this session. Also, I'd like to inform that there's a feedback link that is given in the chat box. I request you all to fill so that we can increase the quality of our webinars. Lastly, sir, I would like to thank you and all the participants for joining with us today.
Thank you so much, Shreya, Kriti, and Divyesh. And I'm so sorry that I had a technological difficulty at my end, not at your end, but at my end, due to which I got cut off in the middle. Apologies for that. And please get in touch with Kriti or Divyesh or even Shreya in case you have any doubts, and they'll be happy to send it across to me and happy to clear it up for you guys. Yep.
Yes. Thank you so much.
Thank you, Shreya. Thank you, guys. Bye-bye. Have a good evening.